Welcome to Court Helicopter Explainer over the weekend. We are dealing with a question that has disturbed very many families. This is where you get a father has a firstborn son. Then their daughters, and the other sons are young. The eldest brother to these siblings wants to marry. Or the mzee feels he's sick, and therefore he decides to give the eldest son some land. In some traditions, the eldest son used to have that land as a trustee for the siblings, especially in the Mount Kenya region where land is registered in the name of the eldest son. Then, when the mzee dies, the man walks to court and say, in succession code, that this land belongs to me. 2, the son has been given land because he's marrying and he has a title deed. Mzee, to empower his eldest son, buys him a matatu, buys him land, buys him a property, puts up some rental houses, while his brothers or his sisters are still in school. When Mzee dies, under the law of succession, the property is supposed to be distributed equally amongst all the siblings, equal, under Article 27 of the Constitution. So this man walks to court and say, the eldest brother, I am also entitled for the estate of my father. Then people say, but you are given land. You are given some property. He says, no, that one I have a title deed. That is not part of this estate. Very many families are facing that question all over. And today, we want to look at 3 cases. The case of, in the matter of the estate of William Mbogori Kadhiama, that is Kirimi Mbori, the petitioner, versus Charity Kainda and Catherine Karea, first and second objector. This is a decision on the 23rd day of May 2018 by Justice F. Gikonyo. We also have another decision here that is in the court at Meru. We also have another decision from Kiambu Civil Appeal number 194 of 2019, Jane Njom Buru, appellant versus Elias Mwangi Njoroge. This is a judgment of Justice Mary Kasango on the 28th day of October 2021. So here, the question that determines this matter is found in section 42 of the law of succession. Section 42 of the law of succession provides that previous benefits to be brought into account where an intestate has, during his lifetime or by will, paid, given, or settled any property to or for the benefit of a child, grandchild, or a house. B, or property has been appointed or awarded to any child or grandchild under the provisions of Section 26 or Section 35. That property shall be taken into account in determining the share of the net intestate, finally accruing to the child or grandchild or a house. What does the law say in very simple terms? After the person, the old mzee, your father, your grandfather, your mother, during the life before he dies, he gave a son or a daughter or 2 sons properties. He transferred these properties when he was alive. He gave a title deed. He gave a logbook of a car. He gave a section of property of an apartment. He registered a company for one of his children. Or he gave this for his either first wife or second wife. They have property that they were given when Mzee was alive, and they have title deeds registered in their name. When Mzee dies, during succession, the court will say, you, Omari, you were given land in Makueni. How much is it worth? 2 million. You, Mary, you were bought a manyanga matatu. How much is it? 2 million. The remainder have never been given anything. The court will say, we first of all allocate the remainder those who have not gotten anything, 2 million worth of property. Then the balance we shall share. So what is the import of this issue? The law is trying to protect the principle of equality under section 27, where the judge said, principle of equality. In law, children of the deceased should share the estate equally. And in this case, there is no surviving spouse, but children. So the law talks of equality. And it moves on to say, where an intestate has left a surviving child or children, but no spouse, the net intestate shall, subject to the provisions of section 41 and 42, devolve upon the surviving children. So the judge is trying to say, in his position, the judge is saying, what is the purpose of section 42? That section 42 of the Law of Succession Act serves two important purposes. One, it fends off selfish tendencies of human beings in seeking for double portion in the estate of the deceased. The selfish nature of human beings who want a double portion. They were allocated a portion, they now want another portion. The first wife had been given 100 acres of land when Mzee was alive. Mzee has married a second wife. After 2 years, Mzee dies. Mzee has a remainder of 15 acres. He has just bought for the second wife. The first wife comes and says, these 15 acres we must share equally. The court will look at what the first wife had been given, what the eldest son had been given. Remember, old people have children they call the most favorite. The most favorite children will be given some gifts. These gifts is what you call gifts inter vivos. The gifts that one gets when the donor is alive before he dies. The law talks of gifts inter vivos must be accounted for when the final estate is being distributed. So the double selfish interest Justice Kasango talks of is cured by section 42. 2, it enables the court to attain equality in sharing out of the estate property among the rightful beneficiaries. This brings equality of widows. This brings equality of what you call siblings. How is this principle applicable to daughters? Many customs, girls are not given properties when the father is alive. Fathers are hostile. They are military-like. They give land to their sons. When they die, the remaining land, the daughters now come and say, we are entitled to get our land. The sons will not be added more land. The sons will not be added on top of what they have been given. First, the daughters will get what is there. If it is more than what the sons have, that is when you get it. So today, you now know Article 42, that is Section 42 of the law of succession, protects children, protects widows under the principle of equality. Any gift you have been given inter vivos before your father dies must be brought to account in the court of succession. Wakili Danstan Omari, always bringing to you the law as it is. Thank you very much.